Jamie, you're going to give me a heads up when we're on?
And we are live.
All right, good morning and welcome to the Juvenile Justice Reform Council, October 8th, 2020 meeting. We're going to dispense with introductions and I'm going to ask our staff, Jamie Lancaster, to call the roll.
All right, Secretary Abed.
Present.
Senator Smith. I don't see Senator Smith. Senator Carter. I don't see Senator Carter. Senator West. Senator West just joined. Delegate Clippinger. I don't see Delegate Clippinger. Delegate Jackson. I don't see Delegate Jackson. Delegate Pippi.
Present.
Secretary Green. I don't see Secretary Green. Ms. Talentino.
Here.
Mr. Kammer.
Here.
Ms. Egan.
Here.
Judge Stamm.
Here.
Ms. Douglas. I don't see Ms. Douglas. Dr. Gilbolt.
Present.
Dr. Lawson.
Present.
Dr. Sickmund.
Present.
Mr. Bayless.
Present.
Deputy Commissioner Sullivan. I don't see the Deputy Commissioner. Mr. Schellenberger.
Here.
Ms. Davis.
Here.
Ms. Mandel. I don't see Ms. Mandel. Mr. Dodson. I don't see Mr. Dodson. Ms. Handy. I don't see Ms. Handy. Mr. Campbell.
Present.
Ms. Chapman. I don't see Ms. Chapman. Mr. Fonseca.
Present.
Mr. Fuston.
Present.
Ms. Johnston.
Present.
Mr. Ford.
Present.
And Mr. McGlone.
I'm here.
And Mr. Secretary, that's the roll. I saw, I believe Delegate Jackson enter the room as we were taking the roll.
And I also entered.
Good morning.
Okay, I didn't hear who said I also entered. We have Delegate Jackson and one other
Sorry.
person.
Stand up,
Oh.
Chris.
Hi, Senator West. I'm sorry. I can't get everybody on one screen, so sometimes I just hear the voices.
Yeah.
Jamie, I'm just going to ask you, or if you could work with James in our agency as well, to reach out to Mr. Dodson and Ms. Handy. I think they've missed a couple of meetings, and I just want to be sure that they're not having any challenges with internet services or anything that might be preventing them from logging in.
Mr. Abed, Miss Handy is on. Hello, everyone. Good morning.
Oh, great. Glad that you're here. So now we just need to check in with Mr. Dodson then and just make sure that he's not having any problems with internet service. Okay, the next item on the agenda is approval of the minutes. That should have been sent out to you and you should have it in front of you. I'll just note in the last meeting, we did take a vote, and at the time I said that it passed. Later, I did amend that and indicate that it did not pass, and we'll be talking about why that happened a little bit later after the minutes, but the minutes do reflect that the item did not pass.
Should the minutes reflect the confusion?
We thought about that. I thought about, should we put the confusion in there? These aren't really the sort of minutes that we would normally keep in a meeting because we're recording everything. The purpose, again, at the beginning, we talked about this, of truncating the minutes, was to clue people in where they need to be. But if you want to put an asterisk, we can amend the minutes to note that the item was called as passed and then didn't, or we can put some language in there if you'd like to.
I would
add
make
that.
a motion to approve the minutes with that asterisk.
Okay, we have a motion and a second.
Second.
All right, any opposed? All right, so with that amendment, the minutes are approved. So the next item is the voting procedures. So this is what the committee generally follows as their voting procedures, and I misinterpreted that. And so I apologize, but you can see what quorum is, which is at least half plus one of the members. So 16 members equals a quorum. And then voting is a majority of the members present. And where I went wrong was not counting abstentions as members present. We need to have a majority of the people, not just a plurality, which is what we had. So that's why the item failed. But I also think that this is fortuitous for us, because I do believe that we were close to a lot more support in that room than what we got in those votes. And so this is an opportunity to get better language and more support for this. And so we will take that up, not in this meeting, but in the following meeting. Hopefully in the following meeting, if we can get the youth charges adult data, which we'll talk about a little bit later as well. So with that, the next item is probation practices and the recommendations. I know that we have Marta here on the agenda. However, what I'd like to do is allow those members that made recommendations to articulate their views to the council, as we did last time. Has Senator Carter joined us? I assume.
I don't believe Senator Carter is in the room.
Okay. Dr. Sickman, you also made recommendations, so I'd like to take you next.
My recommendations were not as specific, but I think there's a lot of research that really supports application of principles that we understand now about adolescent development to probation, which, as I sort of put very briefly, to have probation be much less punitive. We hear a lot of probation folks around the country talking about probation's role being should be much more like being a coach rather than being a referee. That the goal should not be to catch kids doing something wrong and then sucking them back into the system, but rather catching them doing stuff right and encouraging that behavior more and more. And that one would expect there to be some missteps along the way. Just like a group of kids learning to play a sport don't know all the rules, don't know how to do it well. They get coached up so that they do it better most of the time. And part of that would mean, I think, a much different approach to what now occur as technical violations, so that those would be opportunities for coaching rather than opportunities to suck kids back into the system. There's certainly ample research evidence that shows that the system actually can cause more harm than good in terms of lifelong success for kids. So that should be the goal, lifelong success for kids. As a researcher and data person, I would also argue that there ought to be a lot of, people hate the word performance measures, but measures of that positivity, that using youth development stuff. So measuring things about how the system is treating kids. What is the ratio of incentives to sanctions? What is the pattern of behavior. How are kids doing in their community? How are they succeeding? So you're not just using failure as a measure of how well the system's performing by looking only at recidivism rates. And the documents that I provided links to, well, one is a website, which has a ton of information, and thanks to Nate's group for funding that, but also the resolution that our National Council of Juvenile and Family Court Judges passed a couple of years ago that kind of outlines similar philosophy for applying adolescent development concepts to probation practice.
All right. Yeah. And you know, some of the measures that you're talking about, we have others we're trying to get in terms of the positive outcome measures. And, you know, unfortunately, as you'll see, when Ms. Egan gives her presentation, some of the outcomes that we've had in terms of measuring how we do incentives shows that it's not working right. So you're absolutely right. We need to keep that data and we need to collect it so we can measure our performance and how we're doing. And make adjustments and changes as needed.
Yeah, I mean, I think one of the things that that our organization has always sort of believed is that we shouldn't just be measuring the kids' individual success and behavior and holding them accountable, but as a system, we need to hold ourselves accountable to do our best job. And if we're not doing that, if we can't even tell if we're trying, that's a problem. So I would say, you know, definitely circle back with us because we've spent a lot of time with a lot of probation agencies, and we have a similar project now working at reentry measures that we can kibitz with you a little bit.
Great. Thank you, Dr. Sickman. Next is Betsy Talentino.
Good morning, everyone. We did submit one recommendation, and that recommendation is to create a pathway when a petition does get to court, when a young person's case does sort of make it to that deeper end part of the system, to create a pathway back to the front door of the system where that young person could be connected to informal pre-court supervision, receive an assessment and services if they're required. One of the things that I think was highlighted in Vera's presentation last meeting, and it was really clear, is that there are a lot of low risk, low level offenses that land in the probation sort of realm in Maryland. And this would create a way to be able to connect young people and their families to supports in the community without having that deeper end involvement in the probation system. There was a piece of legislation introduced last session that would accomplish this statutory change. And that piece of legislation did pass the Maryland House of Delegates with a unanimous vote. Because of our shortened session due to the health crisis, it didn't have time to sort of make its way to the other chamber so that it could become law. So we're asking this council to consider what we call the return to intake bill as a formal recommendation, and that there be a piece of legislation introduced next session to allow for this pathway to be created in our law.
Betsy, what was that bill number in the House?
House Bill 842, and it was sponsored by Delegate Valentino Smith, and there was a cross file sponsored by Senator Carter, which was Senate Bill 706. And we can send the, there's a link on my recommendation form where you can, if for anybody else, if they want to see what that piece of legislation looked like. But we know pre-court supervision works. We know we get great outcomes. And I think it's a really important piece that we're missing in our system.
All right. Thank you, Betsy. And I'm just going to make one more call for Senator Carter if she's available. And if she's not, I think that her recommendation was to put limits on the duration of probation. It wasn't anything more specific than that, but I want to just put it out there that she did recommend putting limits on the duration of probation. With that, I'd like to turn to Ms. Egan to go through her set of recommendations.
Thank you, Secretary Abed. Obviously, I submitted something that's quite extensive, and I won't try to belabor it, but I just want to go over the sort of key takeaways and large evidence base, and note that most of this information comes from the many experts that we have on this call in this commission, from Nate Bayless to Secretary Abed, who sat on a very important consensus study on this issue, to Dr. Sickman. And I'm just looking across the panel. Lots of this work comes from the expertise that is sitting on this panel. So I don't want to take up all the time, because I do think that there are lots of people that are very qualified to talk about this sitting here. But what we know is that youth probation in Maryland, after what we heard from Vera, does need a major redesign and overhaul. Our system is plagued by indefinite periods of probation, a one-size-fits-all approach. Some of the court orders, for example, for youth probation are just a checklist, right? So it's literally just a photocopy, and people check the boxes of what conditions are going to apply to kids. And that doesn't work for young people. There's growing consensus that probation for young people has to be developmentally appropriate to be effective. And when probation is structured like adult probation, focused on control and compliance, it doesn't work. And so what we want to talk about is designing a youth probation that encourages young people, that gives them opportunities and helps define them as successful young people who are doing well. And so I went through a lot of the data, but one thing that I would ask everyone to look at is the study of the AIM program, which is the Incentive and Sanction Program. The report came out earlier this year. And what we found is that only about half of children were getting any incentive or sanction under that program, and they were getting 9-to-1 sanctions to incentives. And that is just not how it should be working. And so we have to think about how to redesign that. But I would ask everyone on this council to review that study, because I do think it's really telling about where we are in probation in Maryland today. The first thing I think is that in terms of recommendation is that youth probation has to be defined. Right now, we don't say what the purpose is or what the goals are. We have to define youth probation as promoting positive behavior change. And it has to be tied directly to delinquent offenses. I don't know if you've met or dealt with a 15-year-old lately, but if you say, does this 15-year-old need services? The answer for every 15-year-old is yes, because adolescence is hard and difficult, right? So we need to narrowly define that so that probation is aimed at changing positive youth behavior linked to delinquency, not just to adolescent development. And we need all of our prevention and intervention services to be research-based. So my second proposal is that we develop a system for categorizing and measuring the efficacy and fidelity of programs that are delivered to children. I think the most effective way that's been doing that nationally is Washington's bill passed in 2012, which has led to an inventory of services for children, but also a mechanism for the state to develop and work with community partners to give them access to systems for evaluation, so that our more culturally competent and local programs can help show their benefit and their efficacy. My third proposal is that DJS should be required, and this is a policy and a recommendation as opposed to legislation, required to develop policy for streamlining case planning and delivering services immediately. What we know is that the sooner services get delivered after misbehavior, the more likely a child is to link those consequences to the thing that happened. And like Dr. Sickman said, I don't think probation should just be about keeping kids accountable. So often children end up with delinquent behavior and in the juvenile justice system because many systems have failed them. School systems, the social service system, and we are holding young people, children, accountable for the failures of a system that surround them, and that's simply unfair. We should hold DJS accountable and require that probation delivers quality services in a timely, developmentally appropriate, and accessible way. And I have a lot more recommendations. I'm not going to go through them all because, as Secretary Abed mentioned, I think that we should probably address these all separately. But the biggest one is probably number 8 and 9, recommendations for how we should limit probation terms. I propose that we limit misdemeanor, first of all, that we ban, that we don't allow courts to put low risk and low level offenses on probation, that we create a mechanism for post adjudication diversion for those children, and 2, that we limit probation and duration. I link those to the recommendations that came from the National Academy's consensus study and a large meta study about how much time on community supervision is efficient. Now, I put 6 months as a limit for misdemeanor cases, although the study and the meta study showed that that's the maximum amount of time, right? So that is helpful for young people. And we are still setting that out at the max. But I just want to note that those studies are really helpful for showing the ways in which 6 months is a really long time for a 14-year-old. 1 year is a lifetime in the year of a high school sophomore. I don't know if you remember those days. They're getting more and more vague for me. But a year could be an entire life change in terms of how a young person defines themselves, how they feel about the world. And so I just don't want us to pretend that 1 year is a short period of time or that 6 months is nothing. It is very significant in the life of a child. And so I proposed limits of 6 months for misdemeanors, a year for felonies, all but the most serious felonies, and a 2-year maximum for the most serious felonies. And that is because commitments are currently capped at 3 years. And so if we look at that, that would create a real broad range and spectrum of options from 6 months to a year to 2 years to 3 years. And that creates a real ability to differentiate between the kinds of kids and the kinds of crimes that we're trying to address, or the kinds of delinquent behavior that we're trying to address. And I think that there's a lot more proposals in there, but I'm going to leave it at that so that we can have a more robust discussion if necessary.
And Jenny, I'm going to ask you to spend a little time, if you will. First, I agree with you about the year being a long time. I remember my dad telling me to wait a year to get a new bike, and I interpreted that as I'm not getting a new bike. It was just a no. And it probably wasn't his intention, but he just didn't understand how we thought. But number 10 in your recommendations about technical violations, I thought was also really important. If you could just spend a minute or two talking about that.
Of course. So we also saw from the data that Vera presented that the violations of probation are driving a phenomenal amount of children into out-of-home placements. And we know from earlier studies that 2/3 of kids in out-of-home placements in Maryland were there, this is a couple of years back, for misdemeanors or technical violations of probation. Simply put, taking those kids out of the home doesn't just not help. The research shows it does harm. It harms the kids, it harms families, and it harms public safety. So I propose that we limit out-of-home placements for technical violations of probation, and that courts should not commit a minor to the Department of Juvenile Services for things like contempt of court, a violation of probation that does not involve the youth being adjudicated for a subsequent delinquent act. And that's because if the goal of youth probation is changing youth behavior, and there is not a new delinquent act, then that kid should not be being taken out of their home. That just simply belies the purpose of youth probation and of positive youth development. In addition, we don't think kids should ever be taken out of their homes for failures to pay fines, fees, restitutions, for failing to finish community service hours, or any school or school-related issues. What we know is the outcomes of taking a kid out of their home, one of the biggest outcomes is that they never finish school, and that school interruption is worse. So if our concern is school attendance or making sure a child finishes their education, the worst thing we could do is take them out of their home, put them in their placement, then pull them out of that placement and try to fit them back into their home school. So I thank you for reminding me, Secretary Abbott. That's the second largest and most important part of my proposal.
Yeah, and I'll just mention as well that this isn't, it appears to be looking at the court, but it's really looking at the department as well. The department is the entity that generates the vast majority of probation violations. And we have taken steps to try and curb that and limit those technical violations. And you'll see in the presentation that we still have a significant number of probation violations driving detention stays. And so putting statutory framework in place isn't just to try to manage court decisions. This is also, I think, an attempt to manage the decision-making of probation staff that institute these probation violations in the first place. And I'll just add one other piece about, committing kids on a technical violation. We already have in law that we are supposed to be a system that does not utilize punishment. And if a court with, a public defender and a state's attorney come together and decide that this youth should be on probation, that they are not a risk to the community, a technical violation should not then change them into a risk to community safety. So it sort of flies in the face of our existing statutory framework as well. And I think this would complement what we have. So thank you for that presentation. And I want to open it up to everybody for discussion. And actually, before I open it up for discussion, let me just make one comment that I made before we went live. But I think that with these recommendations, and I think that the recommendations, all the recommendations were good, but particularly the ones that the OPD has brought is, I think, a good framework for recommendations that this council could take up. I do think that we wouldn't have the bandwidth to try to do this in this meeting to look at each of these recommendations alone and vote on them. And so what I'm proposing is that the members that made these recommendations, all of those members, so that's Dr. Sickman, Senator Carter, Ms. Egan, and Ms. Tolentino, to come together and to try to form these up into a more sort of manageable, or if we can collapse some things into perhaps bills that could be looked at, legislative actions versus departmental actions, and try and get this framed up so that we can act on these. I think this is a very good framework to use as a starting point. And with that, I'd like to open it up with discussion. And if you want to just unmute your mic and speak, go ahead. You don't need to be recognized because I can't see everybody.
All right. Hi, it's Scott Schellenberger. So regarding the last topic and technical violations, is there at least an acknowledgement that the other parties involved would have to know that a report would still go to the state's attorney's office and to the judge? And the other thing I think is important is, it's my belief that it's the judge who's committing these folks. And I acknowledge that DJS, there may be some changes in approach, but it's the judge who's ordering the commitment. And that decision, is that something that we're thinking about changing? Ms. Egan?
I was waiting to see if Secretary Abed wanted to go first.
No, I'd be happy to hear from you.
So I do think it's a complicated thing. I do think my proposal is to bar out-of-home placements for that. So, for example, 38819 already bars out-of-home placements for certain low-level misdemeanor offenses, right? So for malicious destruction of property and those sorts of things. I think that should be expanded so that that there are things the court can do way short of committing a kid for out-of-home placement, and that kids who are there for technical violations that courts should not be allowed to take a kid out of their home for a technical violation of probation. I actually think, as Secretary Abed outlined, that is supported by the underlying Juvenile Causes Act, right? That if we are not punishing children for misbehavior when it is not a subsequent delinquent act, that we should not be punishing kids, that we should be trying to help them learn. And I don't know I do know that out-of-home placement is inappropriate for those kinds of kids and for those kinds of misbehaviors. So yes, I would say that the courts need to be limited. The other thing, if you see in the AIM study, was that DJS had as a policy that only major infractions should be reported. I don't think the court should be acting as the probation officer. And right now we have a system where that's what's happening too much, is that the court is deciding minor punishments and getting involved, but they don't have the kinds of relationship and rapport building that actual case managers and people in the community should be doing. We should be letting DJS handle misbehavior, handle incentives, and handle those low-level things. The court shouldn't be trying to be both probation officer and court.
So Jenny, I mean, I know you have to have had clients who are living in neighborhoods and homes that are absolutely horrible conditions and situations, and you can see the path they're going to be led on. Aren't there times where getting them out of that environment might be better? I mean,
so if a child is in an environment where they're not safe or there is neglect or abuse, the proper system for that is the DSS system. And the problem is that right now we use a system with cages, jails, and detention, sometimes to care for kids who are abused and neglected. And as long as we continue to allow this system to have carte blanche to take kids out of their home, they're going to be taken out of home and put into cages. And that's not appropriate. If a kid is in a place that's not safe, that where they're not getting the care that they need, then that's an issue for the Department of Social Services, who has a lot more range of options in terms of family preservation and securing that family's future.
So I just wanted to
Thank you.
speak. Hi, everyone. I wanted to speak on Mr. Schellenberger's comment against youth being taken out of a bad place and put into a placement home. I was put into a placement home that was in Emlenton, Pennsylvania. It's called Mid Atlantic Youth Services. And it was a good detention center. However, the setting wasn't for me. I would say that I missed my family a great deal. They didn't have transportation to come to and from. There was a culture shift for me, whereas their consequences was for us to sit on a stool. I never sat on a stool a day in my life. So sitting on a stool was horrible for me for 3-4 hours a day. So you don't know what these other organizations are currently doing in like their process of consequences for you to take them out of a so-called bad place and put them in a good place. And I just wanted to make that comment.
Thank you very much.
I got a question.
I'd like to add, oh, sorry, Senator West.
Go ahead, Senator West, and then Nate.
So let's just hypothesize that there's a person who's put on probation and doesn't comply with any of the terms of the probation at all. Doesn't go to school, doesn't do the community service hours, doesn't do any of the other terms of probation. Under the public defender's proposal, what would happen? What would the consequence be of failing to comply with any of the terms of the probation?
And Jenny, if you want to respond, you can certainly respond. But I do think that there are other actions that courts can take. You can extend the time that they are on probation. You can require them to do other things that they're not otherwise doing.
Suppose they don't do
I'm sorry?
Again, suppose they don't do the other things.
Yeah, I understand, and I think that that's the crux of the question. Is it appropriate to take someone and incarcerate them for being stubborn if they're not a public safety risk? Is kind of the situation. That's how I see it, but I'll let others respond as well.
So I would love Lynn Davis wanted to say something, but I will also say that they haven't done anything except for they have done the most important thing, which is that they have not re-offended. So whenever a kid doesn't go to school or breaks curfew, the underlying thing is the number one most important thing for them to do is not commit more crime. And they have a kid in your scenario has successfully changed their behavior to stop committing crime or delinquent acts. And so I do think that we should give credit where credit is due. And the goal of youth probation is changed youth behavior. One might argue that if a child has no subsequent delinquent acts, that has already been successful.
Can I go?
Lynn, did you have, go
Yeah.
ahead, Lynn.
Yeah, I think that first thing we need to do is to not assume that a youth does not want to comply with the regulations of probation. I think it takes a deeper look to look at, you know, what are the barriers that are in the way of this kid completing these the probationary concerns. You know, it may be that transportation is an issue, or money, or family support, or that the child has mental health issues, or that they have an addicted parent in the home, and you know, and maybe they're taking care of the other siblings in the home. So I think that, you know, starting from that is we can't assume that this child is being non-compliant. We can't assume that they don't want to, you know, to abide by the conditions of probation. And it got me thinking, because of all the materials you sent, the one from, I think it was Annie Casey Foundation, that says a vision for getting it right. And then under probation, they list all the things that we need to do to help youth be successful in probation. One of the things that they didn't mention is these barriers that can come forth. And then some other readings said something about case managers, if they had less kids to deal with, maybe 8 or 12 kids, they could be a force in helping this child be successful in this probation. So,
Secretary Bed, I'd like to make a comment if I could.
Go ahead, please.
All right, so back to the doctor's comments about coaches versus referees. You know, in general, I like that principle. I think that youth particularly need role models in their lives wherever they can find them. I think there is a problem with many households that they may not have them. So my concern would be, you know, looking at the quality of the coaches, so to speak. And I know that in the Office of the Public Defender's proposal, number 3 talks about, you know, connection to positive adults, peers, et cetera. So my concern would be making statutory changes without first having concrete procedures and practices and such in place first before reducing probation periods or reducing placements. I mean, you know, because it's the quality of the coaches. I mean, and if we don't have those, then the only thing we're doing is just not holding anybody accountable. I mean, you know, so, you know, I'd be leery to support a statutory change without ensuring that we have a robust coaching program, so to speak, in place before making those changes. I think that would be the prudent thing to do. And I'm not hearing a lot of that. I'm hearing mostly about reducing probation and reducing this, but not increasing, not the counterbalance, if that makes sense. So
Delegate, you make a good point that there certainly needs to be improvements on the department's end. And I think that when you look at the recommendations, and I mean all of them together, what you really get to is that we need to have a change in culture in the way that we administer probation. And, you know, we can look at that, you know, as well, the department needs to do some things, and maybe the courts need to do some things, or collectively the system has to do some things. But I think legislation aids in that change, that culture change, because it is the state's policy. It's articulating the state's policy that this is how we should do it. And, you know, we can put limits in, and we can also put requirements in, and we may not, you know, get to them 100% right away. But even if they're aspirational, it sets the direction and it sets that culture the way that it needs to be. And I think that's important because we do have to change the way we look at this. And we very much do have a very punitive system. It is a very reactionary system. We put youth on probation and ask them to comply with things. And particularly when we're looking at these technical violations, we know that young people just don't get it the first time on virtually anything. And I'd add, old people don't get it the first time either. If you talk to my physician, she'll tell you that it takes like 3 visits for me to actually change my behavior when it comes to diet or anything else. I have to be threatened with my life. But we know that kids don't react or don't change behavior the first time. When you tell your child to go, clean their room, and they don't clean their room, well, you might have to tell them again. You might have to do some other things. I think that the proposal here is to say, well, do those other things, try those other things. Incarceration isn't the right way to respond to noncompliance. We need to find a way to work with kids and say, hey, look, you've got an opportunity here to leave probation supervision if you can come into compliance with these things. And I think when we look at it all together, it's difficult sometimes to look at pieces alone, but looking at a package all together, if we do change the way that we approach young people and tell them, look, we have goals that we need you to meet. And if you meet these goals, then we can take our fingers off of your, off of you and let you go back to living normally. So let's help get those goals achieved. And that's the incentive that youth would have in order to come into compliance. And I think that if we look at it as a whole package, as everything together, that's what's really needed to change the culture. And individual things probably do look, sort of out there or hanging out there alone, but we need to look at them collectively as well.
But Sam, you can do that now. It's your culture. I mean, respectfully, this is the agency you're running. You don't have to have a statute. You don't need a committee. You can change it now. You can go back to a judge and say, Your Honor, he's done a great job on probation. I want to change it from 6 months to 3 months. I mean, you can do all of that now. And so as Delegate Pippy said, shouldn't we get the change in place before we mandate things, or else you're going to have this lag time? So, I mean, I didn't mean to raise my voice, but it's your agency. Change it. And I have no problem with that. I just don't know that we need a statute that puts limits on individualized cases that may be tried a year from now in Garrett County.
Secretary Abbott?
Yes, yeah, I absolutely will respond to that. And you're right, it is my agency, and we've made attempts to change it, and we've improved things, but we aren't there where we need to be. And I think that, when we look at statutory changes, it isn't just me asking my team to make a change. This is now the force of law, and this is what we must do. And it's a much different conversation when we have the statute behind us versus this is something that the department wants to do. And, I don't want to get into all of the sort of ins and outs of culture change in an agency like this, but it's not something that we can just snap our fingers and do. This is a culture that has been ingrained for years and years and years. And even though we've made efforts, that hasn't worked. And so I'm just going to say that the efforts that we've made on our own haven't been effective. And we certainly are open to trying other things. But I do think that having statutory changes would help in that culture change.
I just wanted to make a quick comment, really, really quick. And I'm sorry, Mr. Hannibal. I just wanted people to understand that the problem that we have today is that people are making these decisions by themselves and not having this youth inclusion and knowing exactly the backgrounds of the youth and what they've been through before they make these decisions. And so I don't want anybody to say, okay, this is your committee, so you need to make that decision on your own. It does need to be a collaboration effort of multiple services that are being provided through these youth as well as the youth themselves in order to make this decision. And like Mr. Abed has said, he's made the moves and been a part of the changes that has come from the DJS, and it hasn't worked. So that's why the committee is here today. I'm sorry, Mr. Hannibal, I'm gonna make sure that you get to go.
Thank you. With all due respect to State's Attorney Schellenberger, and I do respect him deeply, I just think we've talked a bit about how it's the judges that are making these decisions, and it may even be that your office doesn't want somebody in detention, but if you legislatively cabin judges' discretion in ways that don't permit them to, use a hammer when they should be using a scalpel, then you're doing a good service. And so, at the end of the day, and I think the Secretary, Mr. Secretary, you're to be commended for not only embracing reform, but also for the tone at the top. And so, I just wanted to say that because I think it's something that's missing here, and people really should acknowledge that changing culture at an agency like that is difficult. It's painstaking, and you're a happy warrior in that fight, and I appreciate it, and I know others on the commission do as well.
I just want to weigh in.
Okay, I'm sorry. So I saw
Go ahead,
Nate,
Heather.
and I heard another voice. So let's go to Nate first, and then I think it was a Delegate Pippi speaking next.
Sure.
Okay. So I really appreciate this conversation and the comments by Senator West and Delegate Pippi, because this isn't just a policy change. And Secretary Abbott said, maybe we can come together and streamline the recommendations because it's so much. And yet I think the fact that it's so much is illustrative of that probation is a monster in the juvenile justice system. It's not the image any of us have. If we were to read the Baltimore Sun or anything else about what the juvenile justice system looks like, we think about the police on the very front end. We think about youth correction facilities and detention centers. But probation's the thing. That's the thing where the kids are around the country and in Maryland. And so I think that this council has a unique opportunity to put its stamp on what do we think it should look like. What does it mean for us to be on probation? And I think the recommendations across the board definitely speak to the idea of purpose and what are we even trying to do? This conversation has quickly delved into what do we do when kids don't follow the rules? And that's what's broken about probation, that's the thinking, that's what we're trying to do in the first place. We have young people where probably the most common thing across the state is that they are on probation because they broke rules. We deem that they broke rules, and then we give them a whole set of other rules and say, follow these rules. And if you follow these rules for months after months after months, then you'll get off probation. And that it doesn't work. It's not connected to the adolescent brain development science that Dr. Sickman talked about. It's completely at odds with what we know. I appreciate that Ms. Egan had to cut short the things she talked about and focus only on some of it. But I want to just mention one other thing that was at the end of the list, because I think it is important that when we're having a conversation about what probation should be, the part of it is got to be about being realistic about what we expect for young people as the experience of being put on probation. Vera's presentation last time described who's on probation in Maryland. I believe it said 72% of young people on probation are there for misdemeanors. 57% are scoring low risk on DJS's own risk instrument. And yet, over half of all young people on probation are getting electronic monitoring or GPS monitoring, which is something that is an extreme tool to be used purely as an alternative to incarceration. But the profile of young people on probation does not at all fit what we're talking about there. Where if 57% of young people are getting electronic monitoring or GPS, that does not mean it's being used purely for young people with serious felonies. I think the recommendations that Ms. Egan put forward on electronic monitoring are critical in their own right, but also because they speak to what are we prioritizing for young people on probation and what does the experience entail. If the most common program that young people on probation get, where if we are about how are we helping them change their long-term behavior, how are we supporting them, how are we supporting their families, if the thing they're most likely to get is an electronic bracelet on their ankle so that we can monitor where they're moving, that is so at odds with the image. And this is exactly why I think it's up to the council to talk about this, because we know that those things don't only just come from DJS's choices, but those are ordered. Those are ordered through the court. And so I just think I wanted to highlight that one because I think that's an important one for us to take on. But I'm glad we're having this conversation, because if we don't get to purpose, if we don't, as the very first recommendation talked about, establish the purpose of probation as one that actually is about supporting young people, then I think we will miss this whole thing. Our conversation will continue to be about what about when kids break rules? We know they're going to break the rules because they are adolescents. That can't be the way that we define how we help young people who come in contact with the juvenile justice system.
Nate, they put them on a bracelet so that they don't put them in a commitment. That's the reason they give them a bracelet, is so they don't send them to Hickey.
But look at the population of young people getting the bracelet. If those are young people who we're really thinking about sending to Hickey, that's a whole other conversation altogether. If most of the young people who are getting the bracelet are there or have misdemeanor offenses and are deemed low risk by the department. So that's why I bring up the population. I'm not advocating for banning the use of electronic monitoring. I'm saying the routine use of electronic monitoring, so much so that a majority of young people are getting it, and they're more likely to get that than any other service. All the things we're talking about that I just heard people talking about supports for family, about mentoring like Eric's program provides, like Choice or YAP or any of the other programs out there, or educational services, all the things that we think matter for young people and helping them develop, those are all coming in second and third place after the electronic monitoring. And that's the point I'm trying to make.
Okay, I'm going to recognize Dr. Sickman and just let everybody know that as we approach 10 o'clock, we're going to have to end discussion on this and just be mindful that we're going to bring back a revised or more streamlined set of recommendations at a future meeting. Go ahead, Dr. Sickman.
I just wanted to make a couple of points. One, if we craft legislation, there's nothing that says that it has to start the day that it would pass. It can have dates in the future. Things have to occur as of some date in the future to give the agency time to develop some culture change and some additional programming and to get the other agencies and the court on board. So I think that, Mr. Pippi's concerns can be handled, somewhat in that way. I think the importance of legislation is also because while Secretary Abbott, you may be the guy in charge right now and you think that this is a good idea, you're not going to always be the one in charge. And so who's the next person going to be and what are their personal attitudes about it all? It's much better to have some framework and boundaries in legislation. I think I mentioned last time, I would have started the entire discussions that we've been having with that discussion of purpose of the entire juvenile justice system. And then, purpose of probation, purpose of commitment, purpose, so that everybody is on the same page. And then, yes, for that culture change, that's going to require training and, proselytizing really about the culture shift and the purpose. And everybody needs to have an opportunity to become invested in that. And, Ms. Handy's comments about having engagement of youth and their families should be part of that purpose discussion so that it can be part of individual case management discussions as well. Because if it's just the system telling a bunch of people of color in Baltimore what to do, it's just not going to be that effective.
Secretary Abbott, if I may say one thing.
Yes, go ahead, Ms. Handy.
It's Heather Chapman.
I'm sorry, Heather. I'm sorry. I thought
That's okay.
I'm going by
That's
voices
right.
and I thought it was her. I'm sorry. Go ahead.
That's okay. That's okay. I appreciate all of the comments. One thing I would like for us all to remember, just going back to purpose, is that our young people will rise to the occasion. And going back to purpose, you know, with the way that the system is created right now, they, in talking to many of our young people that are on probation, they know that the system is created. That folks are waiting for them to fail. And so in talking to many of them, they know, you know, they say, I don't know, you know, how I'm going to end up getting off probation. A lot of the terms are very fuzzy. And so they get discouraged. And so they don't, they essentially don't, they get discouraged. And so they don't see an end in it. And so if there is a clear end, there are clear supports, they see people rooting for them, and it's strengths-based and trauma responsive and trauma informed. And if we have that type of, you know, system and supports in place, and, you know, kind of, I think like Lynn Davis said before, we're digging deeper, then I think we will see our young people see that, you know, there are people wrapped around them and wanting to see them succeed, and they'll rise to that. I mean, the research says that they'll rise to the expectations and to that occasion.
Can I come back to my earlier question? The answer I got from Ms. Egan was that if someone is consigned to probation under certain terms and fails to comply with any of the terms, all we really should care about is they don't reoffend. Well, if they reoffend, they're going to be back before the court anyway. So if that's the standard, I'm not sure why we have probation. And I heard Mr. Bayless said the purpose of probation is to provide all sorts of service, not to require the offender to do anything, because if he doesn't do it, he's not going to have any consequences. Rather, the purpose of probation is to provide services. But isn't that what DSS does anyway? So I come back to the question, if we adopt the Office of Public Defender's recommendations, why do we have probation at all? If there are no consequences for violating it, and all we're doing on probation is providing services, which DSS does anyway, why do we have probation?
So I'll try to field that one, Senator West. I think the purpose, I mean, and I think, you know, I can tell you what I think the purpose is, and I'll just, you know, echo that, you know, defining a purpose is important for us to move forward here, but it isn't just to hold youth accountable. As I mentioned earlier, punishment is not, at least structurally in the code, supposed to be part of what we do. So the purpose of probation then would be to help youth change their behavior, because they did do something that we have an interest in them not doing, right? We want to change their behavior. And so what we're talking about is, what approach should we take? Should we take a punitive approach to behavior change, or should we take a strength-based approach and try to support youth into changing their behavior? And I think that's where the purpose lies, is in changing behavior.
Hey, Sam, or Secretary.
Yes, Delegate Pepe.
So just to kind of follow up on Senator West's point, I think, and I'll be brief because I know we're moving on, the biggest concern that I have for at-risk youth is them falling through the cracks. And, you know, and that can come in many different ways, whether it's a broken home. So you look at probation, and as flawed as that program is, at least it provides some sort of follow-up. I mean, just think about it. I'm concerned that if you reduce or eliminate probation, similar to what Senator West is talking about, there's going to be no follow-up. I mean, I would almost rather you change the name of probation to a mentorship program. And instead of putting someone on 2 years of probation, they go on 2 years of mentorship with, you know, DSS or Department of Juveniles or whatever. But there needs to be follow-up. And I think that's the bigger issue here. And I mean, even though probation is flawed and there's risk and there's, you know, there are technical violations, at least somebody's following up with them, because otherwise they're just going to fall through the cracks. And so I would really have to hear how the follow-up's going to be. You know, we talk about this coaching program that everyone, you know, assumes would just be there automatically. And I'm not convinced of that. So I think that, yeah, we just need to make sure that, and if we want to change it from probation to mentorship and make a bunch of changes, fine, but there needs to be follow-up.
So I just want to address that briefly, and I know we need to move on. I agree with Delegate Pippi as that I'm very concerned with my clients and young people falling through the cracks. But what we know from the probation and from the presentation we got from Vera is that young people are being shoved through the cracks, right? Young people who on their own would be okay through technical violations are being put into youth prisons, and their outcomes are worse. Kids are not falling through the cracks. Our system is shoving them out of schools, out of communities, and into prisons. So I'm very concerned, not just with kids falling through the cracks, but people being pushed through the cracks by the system. But I do agree with your concern. It's why I front-ended on my proposal that we have to hold the system accountable, that we have to create a way of inventorying quality youth services and mandating that they be of high quality and that they are delivered in a timely manner. And one thing I think is that we can, as a JJRC, make that policy recommendation, say DJS must, or we recommend that DJS enforce this policy while also moving on the legislative end to limit and cap probation to make sure kids are no longer punished for misbehavior with incarceration and instead are given, and this is to Senator West's point, there are lots of consequences and there are lots of things courts and DJS can do short of putting a child in a cage. And I would just ask you to look at the AIM program, which I don't think is perfect, but lists a number of sanctions and incentives that are developmentally appropriate for young people for skipping school. The consequence should not be going to youth prison. For staying out for curfew, the consequence for that, for wealthy children, for white children, is not youth prison. And yet we're talking about using that as a consequence for not following rules. So those are my 2 points, is that I agree that there can be consequences, there can be incentives, but they need to be developmentally appropriate, and we need to hold the system accountable, not just our children.
Okay, thank you for a robust discussion. I think there's a lot to dig into here. I also agree with Delegate Pippi. We should not have a system that allows youth to fall through the cracks and not get services. And I think that we can craft a system that is not punitive and also takes steps to ensure that kids get services that they need in the appropriate systems, whether that be with DJS or with another agency, if that's what's required. I think we can craft something like that. But we are out of time for this discussion. And as I mentioned at the outset, we're going to ask our members that submitted these proposals to put a little more work into streamlining them or into a package that we can vote on, and we'll take that up at another meeting. But at this point, I'd like to bring Marta Nelson back onto the stage, so to speak, and introduce the presentations for our next items.
Sure, thanks. And that was a really great discussion, raising the substantive questions that should be raised. So I was really privileged to witness that. So this meeting has 2 different issues that the council voted on as being important, and we're putting them into one meeting. So there's going to be a lot of material thrown at you. I hope you had a chance to look at some of it in advance. If you didn't, no problem, we will go through it, but there's just a lot of material. And for that, I apologize, but we're moving in a streamlined fashion. The 2 issues are what is continuing to happen in Maryland in 2020 in detention and commitment. We know there were some big changes as a result of COVID and the Court of Appeals order. So this presentation will take the things further to see where we are now and look at patterns. That's one issue. The other issue was out of community placements and out of home placements or commitments, which was another issue that the council wanted to talk about. So we have data on what is happening in Maryland with out of community placements and some things that are happening nationally on that. So we will do this in 2 parts. Selena will talk about where we are now in 2020 with detentions. I'm going to talk a little bit about the national decision-making on essentially how judges are to decide who goes into detention, what different legislative solutions have been. And then we'll have a brief discussion about that. Then we'll move on to the out-of-community placements presentation and discussion. So with that, Selena, will share her screen and share the data on what's happening in 2020.
Perfect. Thanks, Marta. Let me share this presentation. Okay. So as Marta mentioned, right now I'm going to go over admissions to detention in 2020, going over what changes we've seen and what things have stayed pretty stable over time. So just to give some background, this is how complaints have changed throughout 2020. You see that using February as this benchmark of before COVID really hit, that there has been a 56% decline from February to August 2020 in complaints, though there has been an increase since May. And then when looking at how complaints by charge severity have changed over time, you see that in comparison to these earlier months in 2020, misdemeanors and these low-level offenses account for a smaller percentage than they did at the beginning of the year, but still account for the vast majority of complaints. Here on the right-hand side of the slide, I compare this April to August 2020 post-COVID time period to what we saw in fiscal year 2019. And what we see is that crimes of violence and other felonies accounted for a larger percentage of complaints in April through August 2020 at about 27% in comparison to fiscal year 2019, where they accounted for about 19% of complaints. Then looking at how detention admissions have changed over time. So we see that overall there's been a 57% decline in detention admissions from February to August 2020, though admissions have doubled since April. Then looking at predisposition detention admissions as a percentage of petitions filed, you see on the top chart, just aggregate numbers of petitions filed each month and predisposition detention admissions. And on the bottom graph, what you see is that although the percentage of, although the predisposition detention admissions as a percent of petitions filed decreased down to 11% in April, we are now in August at about 25%, so similar to February. Next, looking at predisposition detention admissions by risk, you see that in the month of April specifically, there was a very low percentage of low-risk kids coming into detention, but that this has increased over time in May through August. When looking at April 2020 in comparison to fiscal year 2019, risk youth being admitted into detention. So here we also see quite a bit of fluctuation.
I don't know if it's me or if everybody else is having trouble hearing Selena.
Yes.
Did we lose her?
Selena, you're freezing up. I don't know if you can even hear that.
I think we lost Selena's connection. Okay. Let's just give her a moment to sign back in, and she should be able to continue.
Sorry,
There
I'm
she is.
back. My internet cut out. Okay, let me share my screen again. Okay, so back to predisposition detention admissions by charge severity. So as I was saying before I got cut out, there has been quite a bit of fluctuation between January and August of 2018 in terms of the charges that kids are coming in on. So here it was really just easier to compare to fiscal year 2019. And what we see is that a larger percentage of predisposition detention admissions were for crimes of violence and other felonies in April through August 2020 than in fiscal year 2019, accounting for about 57% in this April through August period in comparison to 51% in 2019. And this was a chart provided to us by DJS in which you could see how weekly trends in predisposition detention changed over time. Here you can see that violation of probation accounts for anywhere between 5% and about 20% each week. Misdemeanors anywhere from about 10% to 44%. Whereas felonies stay pretty stable with reaching a high point of about 25%, and crimes of violence account for a much larger percentage, up to about 50% each week. And finally, looking at disparities, racial and ethnic disparities in predisposition detention admissions. And so what we see over time is that Black youth accounted for the same percentage of predisposition detention admissions in April through August 2020 as in fiscal year 2019, about the same percentage, 76% in this April through August time period in comparison to 78% in 2019. White youth accounted for a larger percentage, 20% in comparison of 14%. And youth who were Hispanic or Latinx or other accounted for a lower percentage. So 8% in fiscal year 2019 and 4% in this post-COVID time period. All right, are there any questions?
Any questions from members before we move on to the next presentation? I do want to just make one comment about admissions versus what our populations look like, and the reason why we added the slide with the weekly data. And it does look, the mix looks a bit different than our admissions data. Admissions, when we look at either complaints or detention admissions, that's who is admitted. When we're looking at this weekly trend, we're looking at what the population look like, more like an average daily population. And so we get a better picture in the average daily population look, or these series of snapshots about who is in the detention center. And with the admissions data, you can kind of see who's coming in, and then between the two, who's going out. So what we end up seeing is we do get a number of low-level kids that come in, and then some of them go out within a day or two, and so they don't have as big an impact in the average daily population. Hopefully I didn't over confuse you with that explanation, but are there any questions? Okay, hearing none.
Oh, sorry, I have one quick question. I'm interested in the percentages, but it sort of seems to bury the lead. That drop in numbers is huge and significant. And I just wanted to know if there was any conversation or discussion about what is driving that enormous drop in numbers. So even with the rise in July and August, it's still more than half what it was in January on a month-to-month basis. So I just wanted to ask if there was any analysis from Vera on what is driving that drop.
Yeah, I think if you go up to the first chart to complaints, that's probably a huge driver right there. Complaints have dropped significantly over this period of time, and I think that's probably the biggest reason why our overall numbers are down. And you're right, the N values, and I think in some of these, yeah, we did put the N values in. So if you look at slide number 3, January we had 1,585, February 1,600, and then you look at August 716. So I mean, this is a vastly different universe, and it's good to, I'm glad that you pointed that out. But that's why we sort of looked at trying to aggregate some of these numbers, because our N values became so small. that we were worried about volatility, and so we aggregated some of this together to try to get a better picture of the COVID period rather than looking at it monthly.
Secretary, oh, go ahead. My question is it fair to say that admission numbers have continued to drop and complaint numbers have continued to be half or way below, even while we're releasing more kids or there are less kids in detention?
I'm sorry, I think I missed your question a little bit, but complaints have dropped. They have basically settled down now. We see the lowest point in May, and it's begun to sort of tick up, but it's not a sort of V-shaped. It's more like a lazy L, if you will, in the data. So yeah, complaints I think are a big driver. But you know, I don't think that it is. Well, the lines look pretty close. I'll let Selena answer the data questions, but do you have anything else to add, Selena?
No, so I would say that it is being driven by complaints. You see that the decreases in both complaints and detention admissions are about the same. They follow a similar path.
And this is Scott. I can tell you that in both the juvenile setting and the adult setting, judges are very much aware of COVID problems. And you know, a lot of places, particularly in juveniles, when they're on the fence, they're going to err on the side of not sending right now. And we're hearing that a lot, both in juvenile and in adult court.
And I was sort of wondering about the complaint decline. Do we have any detail to know how much of that is associated with closure of schools?
I would say a lot, because normally assaults would be a large category, and a lot of those assaults happen in the schools. And since they're not there, they're not happening, and they're certainly without them being around the teachers and the SROs, they're not being reported. So that could be a driver too.
And yet they're not being assaultive at home in their communities either.
I think it depends on, there's not a gathering of people of the same age. It might just be a small group as opposed to, you know, a whole 9th grade class that, you know, creates a lot more interaction.
Yeah, I mean, I know from Jenny's comments when we've looked at data in some places, I mean, sometimes the assaults that are reported at school are what I would call normal adolescent kind of horsing around behavior. Certainly some are, you know, bad fights, but, you know, a kid walking down the hall, pushing another kid into lockers, emulating hockey players could be assaultive behavior too. So it, you know, again, if we're wanting kids to grow up to be good adult citizens, criminalizing what is normal adolescent development behavior may not be in our best interest.
And not to shock you, but I don't think that case you just described should ever come to me. I think it should be handled at the school level.
I'll just note that as a policy matter, we have in regulation, in COMAR education regulations, it says that matters that have routinely be handled as a matter of school discipline are not delinquent acts, but it is only a regulation, not legislation, and codifying that may be one way to change and reduce the use of the juvenile justice system for what should be handled as school disciplinary matters and should never come to court.
Any other comments or questions? Okay, and I think those were very good things to point out, that yes, schools are I think almost all, other than some private schools, going virtual, and certainly that's going to have an impact. And I think that just generally the COVID restrictions that we've had, of asking people to stay at home and you know, not have contact with other people, certainly has a depressive effect on the complaints. And to the extent that that's happening, you know, it's hard to tell, but I think that, you know, we have to acknowledge that for sure.
And yeah.
Lynn, go ahead.
Yeah, I just have a question. While I'm looking at these stats, and they're incredibly important, I'm also curious about what are the percentages of each violation of probation? Like how many kids missed a meeting, or how many kids, you know, what were the different percentages of these violations of probations that got these kids in detention? I mean, I think it would just paint a picture for us.
Well, you know, Lynn, I don't know that we have that at our fingertips in terms of what exactly was the violation, but it is a technical violation if it's listed as a violation as the cause. If they had a new offense, then it would be a new offense, and that doesn't get into that violation category. So all of the ones that you see as, you know, the reason for detention being a violation are technical violations. We probably could break out what the technical violation was if that would be helpful. I think that we could do that. I know, John Irvin, we have you on the line. Is that something you can do? John is our research director.
I'm not sure I can, but I can look into it.
I think we can. Sam, it's such a really relatively a small number of kids, and we can go through them. I will say the majority are there on AWOL warrant type issues with the VOP, but we can definitely dig into that and present that.
Okay. Thanks.
Okay, any other questions before we move on to the next presentation? Okay, Marta?
Okay. So I'm going to share my screen, which is, So I think, I mean, the data is really interesting, and we see the huge drop in complaints and a concurrent drop in placement, or excuse me, detention. To me, I have focused this slide, my presentation, on judicial decision-making around detention, because to me, one of the most salient things was, even with a huge drop in complaints, the percentage of kids who end up in detention is relatively stable pre-COVID to where we are now. We're now at about 25% kids get ordered into detention. And before that, it was, you know, in the low 30s up to like around 27%. So there is sort of, to Selena's point, there's been some massive changes since COVID, but there's also been some consistencies. And one of the consistencies is that judges are still sending kids to detention. And if you look at the risk profile of those kids and the charge profile, there's been some differences in terms of, I think it was 51% of cases in for felonies and high risk compared to 57% now. But still, that means that there's a lot of kids who are there for misdemeanors and who are low or medium risk. So it means that the question about judicial decision making about who should be held pre-disposition and who shouldn't is still a matter that's didn't go away with COVID. So let's look at the Maryland statute, which essentially, you can read it, but essentially says that the child may be placed. It's not a requirement. It's judge's decision. It's discretionary if the action is required to protect the child or others, or if the child is likely to leave the jurisdiction of the court. There is no presumption towards release. There is no requirement that the child be held in the least restrictive environment. In April, the Court of Appeals set out their order about detention and commitment during COVID. And there are 9 different factors here, which I'm not going to read all of them, but you start to see some discussion about some of those things. In Factor 5, the DJS has to notify the court of a viable alternative plan for detention. You're starting to look at, are there other places that this child could be? instead of in the detention environment, which of course has high COVID risks. Looking at whether the release poses a risk of safety to the juvenile or another, and to the extent to which a risk can be mitigated. So you're looking at sort of acknowledging the risk of detention and then looking at how that can be mitigated. And again, sort of these unnamed factors at the end of factor 9, looking at what risk the detention poses to the juvenile, whether there's any condition of release that can mitigate the risk of physical harm to self or others. So you're starting to see this sort of language that is asking the judge really to search all other alternatives before detaining that child. But, so that's, I think, a step forward from where the statute now is. But again, this is an order, this is not a statute. So why do we care? I think this is, I think it's important to go back to why it is that detention is not a good thing for kids. And here are 4 factors. It does increase recidivism if we're concerned about public safety, as I think everyone here is. Even short stays in pretrial detention can increase recidivism, particularly for the kids with low prior history. So there's something about that detention experience that can sort of change the course of their behavior and their course through the justice system. We know that it definitely impacts more youth of color than white youth, even when controlling for the seriousness of the charges and the criminal history. We know that it's a bad thing for young people's health. It creates trauma to be behind bars in this area. It creates mental health issues, and if kids have mental health issues to begin with, it can make them worse. And as we have touched on today, it really interrupts and interferes with their life course of a kid. The kid should be in school. The kid should be doing activities that are going to get them through school and employed. And kids who are in detention have that cycle interrupted. So detention is something that really should be avoided if there's any way to do so. So what have some other states done in terms of strengthening presumptions against detention? Well, New Jersey recently, this is 2015, created a very strong presumption against detention. And I highlighted there, they may not be placed or retained in detention except as otherwise provided by law unless. And if you look at the 2 buckets for detention, they are amongst the most strict that I have seen in any, and I did a lot of this prior to this and sort of looking at the adult system and bail detention. The 2 detention nets are quite narrow. So there has to be, a demonstrative record of recent willful failure to appear juvenile court. And the physical safety question is looking at whether, some very serious crimes in order to say that that child is going to be a risk to the community. Moving on to California. California has their language with a presumption towards release says that the court will hear relevant evidence, and unless, again, the 2 things that the child has violated an order, escaped, or it's a matter of immediate and urgent necessity for the protection of the minor, the child shall make the order releasing the minor from custody. Again, that is a presumption towards release. Another way that some states talk about it is to require the court to place, to make a decision about detention that is the least restrictive of the child's liberty. And here you see this in Delaware, those words, no means less restrictive of the child's liberty, gives reasonable assurance that the child will attend, and the court is required to consider a list of alternatives to detention, in order from less severe to more sort of restrictive. And the judge is required to go through all those things and say, why they may or may not be appropriate. And then I think later on we see that the judge needs to state in writing if the judge, this is back to Delaware, decides to hold a child in detention, even though there's a low risk, they show up on the low risk of a risk assessment, they have to be able to state in writing why they would be overcoming that presumption. So the last thing I want to talk about is the role of risk assessments. As we saw, there were, in Maryland, there's a number of children who are at low or medium risk who are being detained. And so some statutes deal with, how does a court look at risk? Florida requires that all determinations regarding detention have to be based on a risk assessment of the child. And they may order detention if the risk assessment should indicate that. And again, Delaware also requires consideration of the risk assessment. And if the judge is going to overcome a finding that the child is at low or medium, a lower risk, then the judge has to state in writing the basis for overcoming that presumption. So I know that was a bit of a rush through a number of different statutory schemes, and you certainly have the material to look at on your own. But the whole point is that there are ways by statute that that judges can be given more definite direction to order detention only when it's absolutely required.
Okay, I'm going to ask members, if you're not speaking, please mute your phone. We're getting a lot of background noise. If you're on the phone and you're not at your computer, I think, geez, I'm not sure with Zoom what you do if you're on the phone. But anyway, I'm hearing some background noise. If you could please keep your phones muted. All right, we are at 10:30 and we have 2 more presentations. I do want to let people ask questions, but perhaps we can get through those last 2 presentations unless there are any pressing questions right now. Okay. All right, how do we?
Okay. So now switching gears from detention to commitment. Selena is going to talk about where we are now in 2020 in commitments, and then specifically focus on out of community commitments. So Selena.
All right, thanks, Marta. Okay. Yeah, so as Marta mentioned, first we're starting with a similar type of analysis as what I did for detention, looking at admissions to out-of-home commitments in 2020 and how those have changed. And so you see the same pattern here. Overall, detention or admissions to out-of-home commitments have decreased by half from February through August, although there has also here been a slight increase since the low point in April. And here you see commitment admissions by risk. And so you see that between January and August, there was a good amount of volatility, probably again due to the few number of youth coming in each month. But in August specifically of 2020, you see that 72% of young people committed were very high risk, 20% were high risk, 8% moderate, none were low. But when looking at April through August 2020 in comparison to January, February 2020, you see that while a larger percentage were very high risk, 54% in comparison to 40% at the beginning of the year, you see that low and moderate risk youth still accounted for a similar percentage of commitment admissions in these 2 time periods. Looking at commitment admissions by charge severity, you see that this has also changed over time from January through August, though for the most part, misdemeanors accounted for anywhere from 50 to 60% with this anomaly in May, where they accounted for over 2/3, whereas felony and crime of violence charges accounted for also a pretty large percent together. You see when comparing April to August 2020 in comparison to fiscal year 2019, commitment admissions were not very different in terms of charge severity. Again, this is a chart that DJS provided for us where they looked at weekly trends and commitments by charge severity. just in comparing how the data differs from the previous graph I showed was that this shows underlying adjudicated offense, whereas here DJS breaks it down by also looking at for young people who weren't coming in on a new offense, but a violation of probation. And so you see how this has stayed pretty stable by charge category severity over time. And then looking at commitment admissions by race and ethnicity, you see that different from what we see in detention admissions, we see that with commitment admissions, while these disparities still exist in April through August 2020, they've actually narrowed when comparing to fiscal year 2019. So Black youth accounted for a smaller percentage of commitment admissions in April through August at 57% in comparison to 71% in 2019, while white and Hispanic, Latinx, or other youth accounted for larger percentages of commitment admissions in April through August in comparison to 2019. And then changing gears a little bit, looking specifically at out-of-community commitments. So just briefly going over why does being close to home matter? Originally, Vera was planning on doing research that incorporated the voices and experiences of youth and their families and loved ones, but because of COVID, we weren't really able to do that. But we do have some lessons learned from other places we've done this work. And what we know is that most youth consider their family to be a main source of support. And so visits are incredibly important. They provide a wide range of benefits, but the ones we hear about the most are face-to-face contact. They motivate youth to do better. They provide emotional support and help improve youth's mental health. And they allow for meaningful conversations to occur because visits often offer more privacy than phone calls. And so while visits come with a wide range of benefits, frequency of visits from loved ones is often highly variable and dependent on facility location, whereas more rural commitment locations, or of course out-of-state commitments, young people get less visits from their loved ones because of the fact that common barriers include travel distance, transportation difficulties, conflicting work and visit schedules, and visitation rules. And so looking at Maryland specifically, where I was looking at all out-of-home commitments for fiscal year 2019 complaints, just comparing these two samples, commitments had a higher percentages of boys, higher percentage of Black and Hispanic Latinx youth, a higher percentage of young people from Baltimore City and Metro as their region of jurisdiction. And the charges overall were more serious with higher percentages of crimes of violence and felonies, but still 57% of commitments were for misdemeanors. And so looking at commitment location in state versus out of state, most youth in Maryland, almost 90% only experience in-state commitments, whereas 11% of youth experience out-of-state commitments. This 11% breaks down as 6% experiencing both in and out-of-state commitments and 5% experiencing only out-of-state commitments. So next looking at when youth are sent out of state, where do they go? The vast majority go to Pennsylvania, but they're also going to places like Iowa, Alabama, Arizona, Michigan. The commitment types that young people are sent to out of state, close to 40% are sent to staff secure facilities, just under 30% are sent to hardware secure facilities, 20% to residential treatment centers, 13% to substance abuse programs, and 2% to group homes. And on average, lengths of stay are longer for these out-of-state commitments at 5.7 months than in-state commitments at 4.4 months. The biggest differences that you see in terms of in and out-of-state commitments are these gender differences, where 18% of all commitments for girls were out-of-state commitments in comparison to only 7% for boys. More than half of the girls placed in an out-of-state commitment had a misdemeanor as their most serious adjudicated offense at 58%. And then looking at in-state commitments specifically, but not necessarily within region commitments. So 95% of youth, as I mentioned, were placed in at least one in-state commitment in Maryland. As you can tell from this graph that I present, the regions where most commitments are located are not necessarily the regions where most youth live. So while only about 30% of commitments were for youth who lived in central and western regions, 80% of commitments were placed in these regions. Overall, only about 15% of all in-state commitments were within the youth's home region. And then briefly going over commitment release reasons. So within the data, about 90% of these commitments have since been released. Just under half were released as successful, with their average length of stay being 6 months. 23% unsuccessful, with an average length of stay of about 2.5 months. And then 16% transferred, with an average length of stay of about 3.2 months. This other category was really just a catch-all of every other reason that didn't seem clear in terms of success or unsuccess. And that group's average length of stay was just under 4 months. And that's it for me.
Okay, we have time for a few questions. We don't have a lot of time. We do have a couple of things, but questions?
Mr. Secretary?
Yes, please, Delegate Jackson.
Hi. A couple of quick questions. One for the previous slide. So we made mention in earlier conversations, I'm sorry, previous presenter, sorry about that. But in previous conversations, we've had a lot of talk about the bench. And I know that this council has its mission. I'm just wondering if we are coordinating any of these efforts dealing with the bench, because some of the conversations are, crossing over into that realm of what a judge does, what a magistrate does. So that's one statement, probably more so than a question. Secondly, as I look at this chart that's up, there was a pie chart that showed a number of youth that are sent. There you go. Alabama, Arizona, Florida, Georgia, Michigan, Iowa, as well as Tennessee, as well as the youth placements. So coming from the law enforcement world myself, and understanding that, space is always an issue. If a person commits a federal crime, an adult, they may end up anywhere in the United States in a federal facility. The placement of youth in outer state facilities, and even within state, Maryland's a small state, but it can be a very large state if you have limited amount of transportation. So my concern is that a youth is not only committed, but that youth is away from their family or loved ones. And so as social beings, I'm just wondering when these decisions are made, and I guess being a part of the council, this is part of our task here. That is a striking notion. Again, even though I've spent all these years on the law enforcement side of this, seeing these numbers in front of us and really understanding what that means of the separation of that youth from their family and their loved ones, and the psychological effect that plays on them going forward, even for the in-place. I mean, if you're in Western Maryland and you're from Southern Maryland, that's a long ride out there, to visit a person. So comment / question / help. All right. Thank you.
Thank you, Delegate Jackson, and your points are well taken. Regarding the beginning of your statement, the courts are represented. Judge Stamm is the representative of the courts, and certainly we do talk about legislation or policies, if you will, that would restrict court action. That's certainly part of the mandate of the council, that we could look at that. But we do have representation, and we certainly do keep in communication with the courts. And regarding the out of state or out of community, I think it's the way we're putting this, out of community placements. It is a priority for us to try and keep kids as close to home as they can. We acknowledge that the out of state placements are something we don't want to do. We have made strides in reducing the number of kids that we send out of states, but clearly more work needs to be done. And then I think as Selena's presentation pointed out, even within Maryland, kids are generally not kept in their home region. Right. And even within the regions, I think that we're going to see a presentation about some of the other strategies that other states have taken. But even within a region, those are big regions in some cases, very large geographic areas. And as you said, it's not that Maryland is such a large state, but it's a very long state. And if you're living on the Eastern Shore and your committed facility is in Garrett County, you've got a long way to travel. So we do have work to do there. Absolutely.
Yeah, I appreciate that. And, coming from the most populous area in the state, the Prince George, Montgomery County, and, the Southern Maryland region. So thank you, Mr. Secretary.
Can I just address two things that I wanted to make sure the council knows before we move to the next one that wasn't reflected in these slides, is that all DJS run youth commitment facilities are in Western Maryland, and that the drop that we saw at the beginning of this presentation means that our average daily population was over 100 pre-COVID. Our average daily population in DJS run youth prisons has been under 40 for months now. And we are operating 6 youth prisons in Western Maryland with an average daily population across all of them of less than 40 children currently. So I do think that is missing from this data and is very important. And then I would be remiss to point out when we look at those out-of-state placements that the largest percentage of our kids go to Pennsylvania. The most common placement for our children to go prior to 2019, 2018 was Glen Mills Academy, which was shut down for an enormous abuse scandal. Many children from our state were sent to a place that we now know was rife with abuse, as well as children in Iowa and in these other facilities are at Sequel, which is a private prison company that a young man, Cornelius Frederick, was murdered at a Sequel facility in Michigan. And many of those Iowa children are at Sequel facilities, which are privately run facilities. So I would be remiss to point out that there are real problems with supervision and care for our children when they are sent to these private out-of-state facilities. And we have seen widespread abuse scandals, both in Pennsylvania and Iowa, or with Sequel facilities and at Glen Mills in the last few years.
I was going to sort of ask about the cost of placement, sort of as a daily cost per kid or whatever, and how that compares out of state if you include any transportation costs, et cetera, that the state has to absorb. But also what is the state's oversight of those facilities and the youth when they're there? Pennsylvania has a lot of private facilities, a huge vendor network of private facilities. They vary in quality, they vary in popularity, and Glen Mills was one of the more popular places, taking kids from as far away as the, California, but we've definitely had our issues. And I really wonder, what, if any, oversight is happening when kids are sent from so far away? There's like some kind of contract, and unless you're hearing, something terrible, you may not know that terrible things are happening.
So, Dr. Sickman, let me respond to that. We do have a quality assurance process. We do have those folks that are in the Inspector General's office that will review. Personally go and inspect and review those facilities and audit those facilities. And they require, notifications of incidents and that sort of thing. We also require our case managers to visit their kids. And so they will also take visits and visit youth at those facilities. And we talk to our kids and ask them about their experiences there. And then with regards to family visits, we do pay for families to visit their children out of state. If they need airfare, we'll provide the airfare and hotel stay as well.
Yeah, I mean, those things then, of course, add to the cost of the placement. So, and just inconvenience for everybody. But yeah, I mean, certainly Pennsylvania had oversight responsibility for Glen Mills and may have even known of some of these incidents and yet didn't remove their license until the Philadelphia prosecutor's office decided they were no longer going to send kids there. And since that was the bulk of the population, it was basically the first step in the demise of Glen Mills. I would predict that they would resurface in the future, but who knows? The other comment that I wanted to make about sort of the judicial and other decision-making about both detention placements and commitment placements, we are working right now with Drexel University and a small grant funded by the WT Grant Foundation to look at judicial and other decision-making processes that have been affected by COVID to see, can we keep the low numbers post-COVID? We are aware that not just in Maryland, but all over the country, people have said, oh my God, I don't want to send a kid to a facility if that puts them at greater risk of getting COVID. Fact is that those facilities may be harmful and were harmful without COVID, before COVID, and after COVID, there are harms associated with placement. And so I will try to connect Marta at least to the researchers at Drexel, because they have a nice sort of decision tree that could be very useful to Maryland in considering changes moving forward.
Yes, and I'm sorry, who was that speaking?
It's Delegate Pippi.
Okay, Delegate Pippi. Yeah, I just before you go, let me just make one other comment. And you know, as we look at this chart with the percentages of kids out of state, this is looking at some historical data just to put it in context. For a good long period of time, we had generally over 100 kids out of state, and we've worked to bring that number down. Today's number is 13. We have 13 youth that are in out-of-state per diem programs. So. There has been a lot of progress. You know, the percentages can sometimes get lost there, but because the number is so low, I think that we have an opportunity now to really end our use of those out-of-state programs, because we're now talking about a very small number of kids, and we can find those resources, I hope, here in Maryland. Delegate Pippi, go ahead.
So real quick, and I know we kind of breezed through the last presentation, but there was a statistic given, or a statement given, that said that we know that recidivism is higher for those that have been incarcerated or placed. So I just wanted, if someone could just elaborate on that, specifically, the data on that, or I'd just be curious to see if that's related to the nature of the charge, or because that's an important statement to make, because what we just heard was that because of the COVID pandemic and the state of the emergency and the current procedures in place from the Court of Appeals, that is really limiting the amount of individuals coming into the juvenile system, should we just keep it that way? And so, these are some of those broader questions that I would want answered prior to making any concrete policy changes, et cetera. So the first one was.
So let me just point out the site to that is in the presentation. It's a study that just came out this June. It's called The Impact of Pretrial Judicial Juvenile Detention on 12-Month Recidivism. And this study looks at 32 different jurisdictions. And it is specifically looking at pretrial detention as opposed to placement overall. A lot of studies kind of mush them together, but this one is specifically about commitment, predisposition detention. So, so you could, and so that finding that even short stays in pretrial detention can increase recidivism, particularly for kids with prior juvenile history, comes from that study.
And Marta,
Because
and I think what the issue is, and I think you can address this, is that it's looking at kids that are similarly situated with similar criminal histories and similar charges. Some go to detention, some don't, and looking at their outcomes. Is that correct?
I believe so. I mean, I did read the study, but I couldn't tell you exactly the methods. I think what's notable about it is that that's a brand new study, and they looked at 32 jurisdictions, and that's unusual when you look at research. It's usually 1 or 2 jurisdictions, and it's and they're old. So I mean, I can certainly send that study around as well.
Can I add?
And the reason real quick, hold on one second. The reason I brought it up is I don't want to say people that don't go to jail are less likely to go to jail. You mean, do you understand? I mean, you don't want to put that broad, that people that don't go to jail are less likely to go to jail. And so we got to make sure that we're comparing, apples to apples. Yeah.
Yeah, I think Nate is about to say something, because I know Annie Casey highlighted this new study coming out, but you're absolutely right. Studies are very careful to either use control groups or match comparison groups so that they are comparing apples to apples. But
and then the last thing, and then I'm done, is just I brought up a few meetings ago talking about seeing the long-term impacts of the reduction, and I use the incarceration of youth. We've seen because of COVID-19, there has been a significant reduction in folks not only coming into the system, but ones that are at facilities. And then I asked specifically about recidivism because, we kind of have in front of us like a test pilot, so to speak, where because of the pandemic, we have less people, entering these facilities for whatever reason. So, I would really want to know if that actually has an impact on behavior, but I was under the impression that there's a significant gap of information between the juvenile system and then the adult system. So it would be difficult to see long-term what impact of not putting someone in the system has with them entering an adult system down the road. And that's why I keep bringing up that follow-up, right? I mean, because there seems to be a follow-up issue, but recidivism is very important to me because I think that's how we gauge our success by reducing recidivism rates. I mean, we want these kids to have tools so that they're not back in the system or an adult system later. So, thank you.
And Delegate Pepe, to your point, we certainly are interested, and we will be doing recidivism analysis. Of course, we need to wait a period of time, for kids to be either released from supervision or released from detention. We're doing 6 months, 12 months, 24 and 36 month recidivism analysis. But we do need to let that resolve. We do have some preliminary data that I think we've shared with the Judiciary Committee about new offenses for kids that were released from detention or just not detained. But that's about as far as we could go right now in terms of a recidivism analysis. But we will certainly be doing that. We do it every year, and that will help, I think, frame that for you. We are running out of time. We only have about 2 more minutes, and I just want to cover the next items. We have one thing that you mentioned, Delegate Pepe, which is an information gap. And at our upcoming meeting, the next meeting, we should be looking at youth charged as adults. I think that's the next item. However, we have not received the data yet from the courts, and we're working with the courts, the Administrative Office of Courts, to try and get all of the youth charged as adults data. We also are going to partner with GOCAP and see if there is any other way we can get something usable. But that is a sort of an ongoing concern. I want to raise that now. And so we may have to rearrange our schedule to give some more time for data analysis because we haven't been able to get that data. In addition, we have the need for an additional meeting date in December. If you recall, when we put out the schedule, we set out, today for the topics that we're covering today. The 29th we have for youth charges adults, and we're also going to be taking up that lower age of jurisdiction. November 19th has diversion and services. December 10th, education. We did not leave any time for us to consider final recommendations and to sort of wrap all those things up. So I believe that we are going to add a date, December 17th, correct me if I'm wrong, to the calendar, and we'll send that out as an invitation. But we do need an additional date to sort of wrap up the report that we need to write. And I'll just note to the council members that I'm aware that our report is due at the beginning of December, and we are obviously having meetings in December, and that we will just have to submit our report a little bit late so that we have that extra time. With that, we have concluded our time. We're at the end of
Secretary.
Yeah, Nate, go ahead.
I'm really sorry. I just wanted to say one thing because I thought what Delegate Pippi said was really important. And I was going to make a comment about the presentation that Vera just did, and to caution us about, I know we're moving so quickly. This is a great presentation, but we throw around these terms about risk that we need to be very careful to talk about what we mean. And the beginning of this presentation had this whole thing about the kids who are being committed at this point are more likely to be deemed very high risk. And I think it's really important to understand what that means and what that doesn't mean, especially in light of Delegate Pippi's, I think, really important point of understanding, like, what are the actual outcomes for young people who are locked up. And I think one of the things I think it is worth this council to look at the different studies in more detail to understand that when we talk about issues of risk, that first of all, risk assessment tools are not looking at risk of committing a violent felony. They're looking at risk of rearrest or some basic thing. And I agree with Delegate Pippi. We don't want any young people to get arrested because arrest is bad for them, but there's a big difference in arrest that could mean like the school fight that we just talked about versus something really, really serious or something even less serious than that. I think the other thing is to look at studies. What we know is that what does it mean if we believe in understanding risk is the intensity of the intervention we give, that we should be giving the best of intervention. That does not mean locking kids up. And I think it's really important if we look at studies and we can look at each risk level, that locking kids up gets worse outcomes than working with young people in the community. And I think it is important. I think you're right that everyone on this council should be confident in that. They shouldn't just take it as like a talking point that locking kids up is dangerous. We should understand that. We should understand the science behind it. We should understand the research behind it. That it's not just a political point of view, but that it is rooted in what we know about working with kids. So I think unpacking risk, I know we don't have time today, understanding what that actually means and doesn't mean, and then actually looking at those types of studies, I think would be well worth the time, because I think Delegate Pippi is right.
Thank you, Nate, for that final comment. With that, I'm going to ask for a motion to adjourn.
So moved.
All right. Any second?
Second.
All right. So without objection, we will go ahead and adjourn the meeting, and we'll see you at the next meeting. Thank you.